Good morning, and thank you for joining me on the path to liberty. It's Monday, November 8th, 2021, and on this episode, I'm continuing my series covering the papers of one of the most prominent Anti-Federalist writers who went by the name Brutus. And today, I've got highlights from his 12th paper, where he continues his examination of the proposed judicial branch. And here he really hammers home his expectation, and I think he pretty much called it on a lot of this, that the federal courts will focus instead of on the legal meaning of the words and phrases and clauses and articles of the document. They'll focus instead on the spirit of the Constitution, which is really a warning about this living, breathing Constitution. We can understand how it means based on some kind of just unknown or general goals in the head of the judges, and then the judges can expound the meaning of the Constitution from that. And because of that, he said the end result would be an expansion of power, not just in the judicial branch, which we've certainly seen, but a consolidation and centralization of pretty much everything else within the hands of the federal government. And today, we live under the largest government in the history of the world. So if that is not a consolidated government, there is no such thing. But first of all, before getting to that, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. For those of you who've got really good headphones or earbuds, you might hear some jackhammers in the background. I guess we've got some government-run make-work projects going on just outside my window this morning, so I apologize for that, but the show must go on. Anyways, our show homepage, 10thamendmentcenter.com/path to liberty. There you're going to find everything you need to follow the show, all the archives for about 3.5 years, individual episodes like this one today, which I publish a blog for about an hour to 2 hours after the live broadcast is done. There you're going to find links to stuff that I'm talking about. So if you've got a question like, hey, you mentioned this URL, where is it? You got to go to our show homepage, and then you'll see the episodes there, and you just look through, you scroll down, you're going to see show links. 10thamendmentcenter.com/path to liberty. Also on that homepage, you'll find all the different platforms we're on. And I know everyone has their own favorite platform. Sometimes we use platforms that we can't stand because that's where everyone else is. So if you happen to notice that we're not on one of the mainstream ones, of course, we live stream on YouTube and Facebook and Twitter and Twitch. We also live stream on Odyssey.com, which is decentralized and censorship resistant. We're very happy to be on a bunch of other different platforms. Gab TV, Ben Swan's Sovereign.media. We're on Brighteon and BitChute and BitTube and all over the place. Rumble, MeWe. I can't even think of them right now. But we also have an audio-only podcast edition, which actually is doing really, really surprisingly well, especially considering I wasn't even going to do this as a podcast. I was just going to do a YouTube show originally. And even our membership program you can find there, where you can support us for as little as $2 a month. Again, 10thamendmentcenter.com/path to liberty. A quick hello to everyone out in the live chat before we dig into Brutus. Tim Martin over in Arizona, Cheriton Farmer in Missouri, in Alabama, Dixie Strong, Sharon Patriot, Ryan Korn in Iron Mountain, Michigan. Awesome. I've been talking with some people about doing an event there next summer. I'm not sure about the scheduling, but possibly I'll be in Michigan. Not in Iron Mountain, but Clay Kent, Philip Lavery loves the intro. Thank you. Ryan Korn, Casey12112, Jennifer Coop. Hello to you as well. Tom Casey says hello to Liberty Junkies and Jeremy Anderson. I appreciate you all being here. I apologize for anyone I miss. I'll take a look at questions and comments a little bit later, either in the show or later today. So let's get to this. Brutus's 12th paper, and I'm not sure why it's like this, but everyone breaks it down into two pieces. It was published on two different days, February 7th, 1788, and February 14th, 1788. And maybe it's because so wherever you look this up, or wherever it's generally published or archived, you'll see Brutus number 12, part 1, which I have here from, what is the URL on this one? This one's teachingamericanhistory.org, which I use for these quite a bit. And then there's another one for the following week, paper 12, part 2, but it's interesting because in the Federalist, a lot of them start out with the same subject continued. They're obviously a continuation and a flow and a discussion of these things, but maybe because they were considering that it's possible that he wrote this all out at once and decided to publish it in sections. I don't know. But anyways, I've got at least those two that I'm covering here. And he starts out by saying, in my last, he reminds people what he was talking about, the problems that he expected. He expected, there are three main reasons why he expected the structure of the judiciary to lead to a consolidated government, and then he's going to go into a little further. He says, in my last, I showed that the judicial power of the United States under the first clause of the second section of Article 8, Article 1, Section 8, first clause, what's that? Would be authorized to explain the Constitution not only according to its letter, but according to its spirit and intention. Now, if we understand the legal meaning of a document, the legal meaning is not the intention of the people who wrote it up, it's the understanding of what it meant by the people who gave it legal force. So if two people are signing onto an agreement and they understand that red means blue, then the word red in the document means blue forever, until they change it, not just because some judge changes it. So as Samuel Adams put it once, he said, he and James Otis Jr. in the Massachusetts Circular Letter in 1768 were very clear. They said, in all free states, the Constitution is fixed. A living, breathing Constitution is the definition of a tyranny, is really the message that we're getting from that. Anyways, going on, the judiciary, he said, would not only look at the legal words, but its spirit and intention. And having this power, they would strongly incline to give it such a construction as to extend the powers of the general government as much as possible to the diminution. I only got that one from reading. First time ever saying it out loud. And finally, to the destruction of the respective states. So the founding generation, the old revolutionaries, looked at the greatest threat to liberty as being a consolidation, the consolidation of power. And they fought a long, bloody war against a British government that claimed the power over the colonists, quote, in all cases whatsoever. So when Thomas Paine in the American Crisis of December 1776 was urging people against all odds, you got to go on, because even if they pretend to be nice to us today, they're still claiming the power over us in all cases whatsoever. John Hancock reminded people of this in his great Boston Massacre Remembrance Day oration in the 1770s. All cases whatsoever. So centralization of power is a serious problem. Brutus, in his previous and going further in this, talks about how centralization of power will come from the judicial branch. He says, I shall now proceed to show how this power, after summing up his previous paper, will operate in its exercise to effect these purposes. In order to perceive the extent of its influence, I shall consider three things, and he doesn't cover them all in paper number 12. In fact, he covers one in the first half, second in the next half, and then we got to see where he goes on the third. But anyways, first, how it will tend to extend the legislative authority. He expected, and he predicted, that Supreme Court opinions would continually expand the power of Congress. Wow. He definitely called that one. Second, in what manner it will increase the jurisdiction of the courts. And of course, the courts have actually given themselves jurisdiction over all kinds of stuff that was never intended under the original legal meaning of the Constitution as understood by the people of the several states, the people, the ratifiers who gave it legal force. And then third, the way in which it will diminish and destroy both the legislative and judicial authority of the United States. So he's even saying it's bad for the general government. Anyways, hear from founder of the day, who I cite pretty regularly. It's a guy named Jason Mandresh. This is an awesome website. A lot of really just obscure, very easy to read information. Founderoftheday.com. You can also follow him on Twitter as well. He says, Brutus writes that he's worried about the justice's ability to read into the spirit of the Constitution. He believes that as the Supreme Court rules on law passed by Congress, Congress will learn to play by those rules. So they're not going to try to go beyond. In fact, they're going to look at stuff. Well, what are the Supreme Court precedent on this? He talked about the concerns regarding precedent in his previous paper, and he expected Congress to play with that and work with it. And then over time, one of the other problems he mentioned is the general expansion of power. Power will always expand. So over time, this means it would grow and grow. In this situation, Jason writes, Congress would make laws based on what they expect from the Supreme Court, giving the Supreme Court an unspoken authority over Congress and taking away that branch's independence. So if we're basically in a situation where the Constitution means what the Supreme Court tells us it means until it changes its mind, in essence, instead of having three co-equal branches, we're really living under an oligarchy. In essence, we're living under the rule of 9, in many cases, 5 unelected, unaccountable, politically connected lawyers with life tenures. And he's very concerned about that. He goes a little bit further, but it's not just independence of Congress. He actually expected it to expand them. And here's how he put it. In determining these questions about stuff that arises under the Constitution, the court must and will assume certain principles from which they will reason in forming their decisions. These principles, whatever they may be, when they become fixed by a course of decisions, again, this is referencing stare decisis, the doctrine of precedent. So as soon as they have precedent, stare decisis basically says you go with the precedent in many situations, even if you think the precedent is wrong. Now, not necessarily on the Supreme Court, but they generally don't overturn their own precedent. It's not in good taste for them. It certainly would be for them to overturn almost everything they've done. But anyways, these principles, whatever they may be, Brutus writes, when they become fixed by a course of decisions, will be adopted by the legislature and will be the rule by which they explain their own powers. And in his last paper, as we're just summing this up, 3 reasons why the courts would then expand the power with this approach. 1, there are general and indefinite terms. There were terms and phrases throughout the document which even lawyers of the time were debating. General welfare, necessary and proper. I mean, we can understand what the original legal meaning of necessary and proper is because we know, according to James Madison and so many others, that it was explained under the legal doctrine of principles and incidents, which I'm not going to cover here. But there's debate over this. And Brutus was like, hey, if we're even debating what these mean now, what's going to happen in the future when not only are the courts looking for what the legal meaning is, but maybe what the goal of such a thing might be? They're going to just go nuts with this stuff. So 1, general and definite terms. 2, we know that power always corrupts and expands. And then 3, precedent, which I keep mentioning here as well. I covered those 3 in much more detail in his on paper number 11, which I did a few weeks ago. Unprecedented Judicial Power, Antifederalist Brutus number 11. That will be linked to in the show notes. Show notes are 10thamendmentcenter.com/path-to-liberty. I always get a lot of questions about where was that link, so I'm going to keep mentioning this. So if you're listening to the show or watching it, you know the show homepage is where you find the links that I'm talking about. Back to Brutus. He says, from these observations, it appears that the judgment of the judicial on the Constitution will become the rule to guide the legislature in their construction of their powers. What the principles are, which the courts will adopt, it is impossible for us to say. And that's the concern. If a free state means a constitution has fixed laws and rules, then if you don't know how the judges might think about specific legal doctrines within the document, then you don't have a fixed constitution. You aren't a free state, and things are going to go off the rails. And as I mentioned a few months ago in an episode, when did the things go off the rails? As early as 1791. I said 1791. I would say some people that I respect, Brian McClanahan, Dave Benner, and a few others, would probably say as early as just in the first few months after the new government started taking over. Anyways, taking over. Wow. It is impossible for us to say what these principles are, but taking up the powers as I have explained them in my last number, those 3 concerns, which they will possess under this clause, it is not difficult to see that they may and probably will be very liberal, very broad way of reading into things like general welfare, commerce, necessary and proper, and he was very concerned about them using the preamble as a legal pretext, even though we can even look to the people who drafted the primary drafter of the preamble is pointing out that this is just a recital. In legal documents, a recital is a statement of principles. It does not give additional legal force, but he was expecting the courts to read the preamble as a way to guide them in understanding this living, breathing spirit of the Constitution approach and then expand power all the time. Back to founder of the day. Jason writes, Brutus then goes into the spirit of the federal government by diving into the Constitution's preamble. Interestingly, he notes that to, quote, form a perfect union, the nation would need to eliminate the states altogether. Now, a lot of people thought he was very alarmist, basically saying you're not even going to have states, you're going to just have one central government to rule them all. And today, if we made the case that he said that, we'd say, you know what, he called it wrong. But in technicality, there are still states. But in most situations, everything is uniform. And the more that they come up with rules and regulations and mandates, and then Supreme Court opinions under the incorporation doctrine, which forces everyone to do everything the same, and they water down our rights everywhere, the less that we actually have states in practice. They really act like oversized counties to the federal government. Anyway, so he was concerned about things being totally consolidated. Here's how he put it again. If the end of the government is to be learned from these words in the preamble, which are clearly designed to declare it, it is obvious it has in view every object which is embraced by any government. Now, that is not the correct legal reading of it. And in a lot of cases, I think Brutus was pretty aware, because he made it pretty clear in an earlier paper that, like, I know that the lawyers are saying this, but that doesn't mean that's how it's going to work in practice. And that's what he's concerned about here with the preamble, with its beautiful prose and its broad language. He says, if it be further considered that this Constitution, if it is ratified, he says its concern is that it will not be a compact entered into by the states in their corporate capacities, but an agreement of the people of the United States. Patrick Henry was concerned about this as well in the Virginia Ratifying Convention. He said, who authorized these people to say we the people instead of we the states? This is not a singular country. This is a union of independent sovereign states, as it was very clear in the Treaty of Paris and the Declaration of Independence, in Samuel Adams when he said, explaining the Declaration to the people, urging them to be in support, he says, you know, may these states always be free and independent. They're free and independent countries, really. So he's concerned about this as well. He says, no doubt can remain, but that the great end of the Constitution, if it is to be collected from the preamble, in which its end is declared, is to constitute an government which is to extend to every case for which any government is instituted, whether external or internal. Even though James Madison was saying in Federalist 45 around that time, and I'm not sure if it was already published, I think it came out just in the previous weeks, but the powers delegated to the federal government, Madison said, were few and defined. Those reserved to the states were numerous and indefinite. So the Federalists were taking that position, and Brutus was saying, you know, even though that's what you're telling us, this is not how it's going to play out in practice. And we can actually learn two things. One, how it's supposed to be, what Madison told us, and two, what government does. They don't care what it's supposed to be. And unless the people resist government when it does stuff it's not supposed to be, it's going to grow so immense to what we have right now. Brutus goes on. He says, the courts, therefore, will establish this as a principle in expounding the Constitution, and will give every part of it such an explanation as will give latitude to every department under it to take cognizance of every matter, not only that affects the general and national concerns of the Union, because the federal government was supposed to be a general government. And in fact, when you look at the writings of the time, Thomas Jefferson, even in the 1790s, was still calling it the general government because it was going to have general concerns for the nation. The specific, the police powers, basically everything else that affected the lives and liberty and property of the people were to be, dealt with whether or not the people wanted to on a state-by-state basis on the state level. That's it. So he says, it's not going to be a general and national concern, but also of such as relate to the administration of private justice and to regulating the internal and local affairs of the different parts. And sometimes Brutus was way off base, but I think in this one, he really, really nailed it today. We've got a centralized power, largest in history, which I can't stop repeating, that tells us how big our toilets can be, what kind of light bulbs we can buy and sell, what kind of plants we can grow in our own backyard and consume in our own home, how we can defend ourselves, whether or not even the restrictions on it apply to the states. It's just, they basically make the decisions about everything. And if it's such a large, we don't want these people involved in our lives. In fact, if we start taking the approach that we want to turn our back on them, we can't go to them to protect us because they do so much to violate our liberty, I think things will be much, much better. Anyways, going further, this is a paper by Shlomo Slonim from the University of Minnesota Law School back in 2006. He says, the spirit of the Constitution, Brutus claimed, can best be deduced from the preamble, which included the comprehensive term to provide for the general welfare. That's not the general welfare clause that we're generally hearing as one of the elastic, most expansive ones. Quote, If the spirit of this system is to be known from its declared end and design in the preamble, its spirit is to subvert and abolish all the powers of the state governments and to embrace every object to which any government extends. And he says if this equitable, this is looking at the spirit, looking at it under equity, he says if this equitable mode of construction is applied to the General Welfare Clause, Article 1, Section 8, he says nothing can stand before it. This approach to the judiciary, which we certainly have today, will give the first clause in that article, general welfare, a construction which I confess I think the most natural and grammatical one, to authorize the Congress to do anything which in their judgment will tend to provide for the general welfare. I mean, how many times have we heard Congress say, we're going to do this? And it doesn't matter what arguments you say against them. They're basically going to go with whatever the Supreme Court has authorized them to do, sometimes try to push it a little further. Then the Supreme Court backs away a little bit. And so they never tell us that they're not authorized to do something. They just keep doing more and more and more. He says this amounts to the same thing as general and unlimited powers of legislation in all cases. This approach to the Constitution, Brutus warned us, would authorize the government to have a general and unlimited power to legislate. Not that that's the right way, but that's what he warned us against. And again, if we have a government that is so involved in our daily lives, you might tell me, oh, well, you can still say stuff, Bolden, you're doing this show. Well, that doesn't mean that they're not claiming the power to involve themselves in anything and everything all the time. I mean, we see it happening before our very eyes. Here's what Shlomo has to say about it. Now, this is, of course, a transfer, or he's actually transitioning from part 1 of this 12th paper to part 2 here. He says, this was particularly so, this kind of general and unlimited approach, especially in the view of the expansive nature of the necessary and proper clause, which would, quote, undoubtedly be an excellent auxiliary to assist, man, I am really stumbling over words today. I apologize for that. To assist the courts to discover the spirit and reason of the Constitution. So he's saying, look, they're going to look at general welfare. They're going to take the preamble. They're going to use this approach to look at the spirit of it rather than the original legal meaning of it. Then they're going to add necessary and proper. The Congress is going to have whatever power that they feel is necessary to promote whatever they think is general welfare. And as a result, Shlomo said, the powers of the government would extend to every case and reduce the state legislatures to nothing. And this conclusion emerged from this in part 2 of his paper. I think this is in part 2. Let me see here. Yep, this is in part 2. Quote, where the Constitution gives the general government exclusive jurisdiction, they will adjudge all laws made by the states, in such cases, void ab initio. That's my best Latin. So he was expecting the courts to actually take a power over state laws and basically anything that they say that they have the power of. Now, when it first started, they didn't claim the power over everything. But over time, that power expands, and then more and more and more, the federal government has the final say in everything. And we hear people today say, well, the supremacy clause means the federal government is always supreme. Not only if it is doing stuff in pursuance of the delegated powers. And even if they do say that, they'll just say, well, that's under the delegated powers. To them, everything is a delegated power. Everything. Where the Constitution, he says, gives them concurrent jurisdiction. So there's concurrent jurisdiction on various things. The laws of the United States must prevail because they are the supreme law. And he says, from these remarks, it is easy to see that in proportion as the general government acquires power and jurisdiction, so as it expands its power and jurisdiction, which is done year in and year out, decade in and decade out since the beginning. I mean, a lot of us will say 1913 or 1971 or the 1940s New Deal or 1861, 1865, but really, since day one, they've really, well, maybe like day 100 or so, they've really started on the path, the wrong path, not to liberty, but to tyranny, to centralization and tyranny. Thomas Jefferson, in his arguments against the national bank, the first national bank, the first, basically, the Federal Reserve central bank, in 1791 said to take a single step beyond the limits of the Constitution is to take over a boundless field of power. This is the same message that Brutus is giving us here. They're basically claiming if they can claim the power over us in all cases whatsoever, federal law is always supreme, this is unlimited. He says, it's easy to see that as they expand their power and jurisdiction, by the liberal construction which the judges may give the Constitution, will those of the states lose its rights until they become so trifling and unimportant as not to be worth having. I gotta say it again. Dude called it on this one for sure. Well, I hope you guys found this interesting. I hope it was educational. I hope you learned something. Of course, and I'm going to look here in the live chat in just a moment or so. Please consider smashing the like button if you're enjoying the show, leaving a review on Apple Podcasts or any other podcast platform, subscribing, getting notifications, whatever platform you happen to be using. Please do all that stuff. It triggers the algorithm primarily of the mainstream platforms. Some of these other niche ones, definitely, I don't know if they're very algorithm-based, but the mainstream ones, certainly. And the more you do that, the more it'll show the program to more people, especially on the podcast edition. So thank you so much for helping me spread the word. Taking a look over in the live chat, seeing if there's any questions that I can answer. Oh, hello to Patricia Dance, Ryan, Justin, and Ite Lander in South Carolina. Tom Casey said they fought that bloody war knowing our generation would squander their work away. Yes, and that's an interesting point. You can't actually control the future, right? And when Benjamin Franklin told us on September 17, 1787, Constitution Day is what we call that, the last day of the Philadelphia Convention, that he expected the government to be administered pretty well for a number of years, and then over time, the people would just need, it would only end in despotism. So in a way, I don't know if they were necessarily fighting the war, knowing that a future generation would screw things up. But I think over time, we certainly see indications, even in the Federalist side of things, warning that, well, we got to just do our best with what we've got now and leave posterity to its own kind of courses. So that's an interesting point, and I appreciate that, Tom. Thank you for saying that. Hi to Haji in Oakland County, Michigan. Jennifer Coop says, how do you feel about the court's current role in the current mandate situation? Well, I did an episode. Of course, when something comes before the courts to deal with the Constitution, they should actually point out where the federal government is doing stuff that isn't authorized by the original legal meaning of the Constitution. But relying on them as a strategy is not a really good approach. And I think most people in trying to deal with this are like, we're going to sue. And I think we saw that happen with the Affordable Care Act. It was just, instead of resistance, instead of nullification, we saw little lights of that, little flickering of that type of activity, but it was basically wait for the courts, wait for the Tea Party, wait for the next round, wait for 2010, 2012, 2014, 2016, just keep waiting on this other stuff and never do the resistance that's needed on a state, local, and individual level. So yes, I would like to see the states or the court say that this is unconstitutional. That would be great. It would be very unusual. Usually when they do something like that, they kind of carve out exceptions and power keeps expanding. Then you look back on it in 5-10 years and you're like, oh, wow, look what they set up. For example, the Gonzalez versus Raich case in 2005, when Justice Scalia, the so-called great conservative constitutionalist, told us that growing 6 plants in your backyard, never buying or selling them, never taking them across state line, consuming them in your own home somehow counted as interstate commerce. And many conservatives were fine with that. They didn't care about the 10th Amendment. They were fine with it because they support the drug war. They don't like California legalizing cannabis in spite of federal prohibition on the same. And so then that same opinion from Scalia was used in the 2012 ACA case, NFIB versus Sebelius. And that was another argument for expansive federal power under the Commerce Clause. So each of these steps, whether you like the short-term results or not, is probably not good. Anyways, that's kind of a very long answer to a really good question. I appreciate that, Justin. Haji said this, Brutus was a visionary, clear-thinking prophet. Maybe in some ways, certainly. I think a lot of the founding generation looked at history. They understood that if you have a similar situation in the past and you set up the same type of thing today, you're going to have the same results in the future. And I think that's what Brutus was doing. I think Rothbard considered him one of the most honest and well-written ones in his great writings on American history. Anyways, Tom also asks, how can we change the mindset of a population of 330 million? That's a really big question. Tim Martin says SCOTUS is about to expand on incorporation. Yes, they always want to get involved in more stuff. And the end result, sometimes we get good short-term results, but the big picture is we're basically putting the fate of all of our liberty in the hands of 5 people. And we don't know who those 5 people, and they may change their mind in the future, and that is consolidation of power. And it's not good, even when they do something good. So thank you for mentioning that as well, Tim. Neil McBee says promote, not provide, like other charges, the general welfare. Good point. And let's see what else. Philip Lavery asks, if Alexander Hamilton was alive today, would he like all the overreach, or would he even be horrified? I don't know. That's a really interesting thought experiment. And he certainly was I've gotten some complaints that I basically complain about Hamilton too much on the show, but he was a real problem because even where he was telling the truth, he would just flip-flop back and forth. And I think some of the other big government people, Governor Morris, James Wilson, they told a story and they kept to it. Even Madison we could consider a big government guy because he was really pushing for something called the Virginia Plan at the Philadelphia Convention, which would have given the central government, or the general government, I guess, a veto power over every state, any state law, all of them. That's what he thought was essential. He wrote a letter to George Washington before the convention started saying, we need this. This is a defensive power against the states. And then when he didn't get it, that failed to come to fruition. He never actually made the case for that again. I think he just said, look, this is what we got. Now I'm going to support the way it's supposed to be. That doesn't mean he was consistent on everything. But Hamilton was a flip-flopper. He was the other way around. He would tell people what they wanted to hear and then change it to get his goals. I don't know. He was a big government dude, but even in comparison to today, the stuff that he argued for was just minute in detail. Anyways, Hamilton was not a fan. Clay Kent's not a fan of Hamilton either. Anyways, I appreciate you guys spending some time with me today. If you support what we're doing, please consider a membership to the TAC. It starts out as little as $2 a month over at 10thamendmentcenter.com/members. We do a lot with that. We make $2 a month go a long, long way in support of the Constitution and liberty. Don't feel pressured to do that. But if you do have a few dollars a month, or if government's throwing some loot your way, we'll take it. We'll take their worthless fiat and spend it on stuff to spread the message of the Constitution and liberty, how to defend it as well. And of course, smashing the like button, reviews, and all that other stuff really helps out a great deal. I will look through the comments a little bit more later on today, see if I've got any ideas for future episodes. You can also email me at team@10thamendmentcenter.com. I really appreciate you being here. I hope you enjoyed the show. I hope you had a great weekend. And I will see you on Wednesday here on the Path to Liberty.